Okay, talking now about suspension of operations. There are two types: full or partial suspension of the operating portions of the business that are more than nominal. And two, supply chain disruption. The most important thing to remember here is that we're still looking for the effects of government orders. Let me first say, you don't have to generate a bunch of paperwork on any of these standards right now. However, you will need to attest that you could find this evidence if called upon to support these things later. The best time to locate these orders is now. Let's be clear right off the bat. The general rule is this: if your business was deemed essential by a governmental order and all its operations remained open and functional, the business does not qualify for ERC benefits while those orders are in effect, okay? But there are gray areas. What if parts of the business were closed or restricted by government order? Well, it may still qualify under the facts and circumstances at play. Again, we're still looking for government orders limiting commerce, travel, or group meetings for commercial, social, religious, or other purposes due to COVID-19. If those orders limit more than nominal portions of the business, it qualifies. So what's that mean? The IRS defines more than nominal as 10% or more of the business's operations as compared to that same period in 2019 in terms of two things. One, gross receipts of the business, or two, employee hours of that part of the business. Allow me to use my loaf of bread analogy here to drive this concept home. Think of your business as a loaf of bread, and the loaf has 10 equal slices. Spoiler alert, I'm having you visually picture your business in 10% increments. Here's which slices matter. Slices, or parts of the business, that make up at least 10% of the whole business in terms of two things. One, gross receipts of the business, or two, employee hours of that part of the business. Example: a law firm practices primarily in wills, trusts, and estates. 20%, or two slices of the whole loaf in terms of client fees, represent probated cases that are litigated in court. Orders close the courthouse and restrict vital deposition. Those quarters qualify because it's more than a nominal part of the business. Now, here's the question for you. Are there one or more slices of your business that were closed or restricted by a COVID order in 2020 or 2021? I know that this is a weird concept and nobody ever thinks of their operations in this way unless you're applying for the ERC. But just pretend you were selling your business and you're separating it out into different valuable parts. Some of the valuable parts a buyer might be interested in buying. Other parts, the buyer might not have any interest, and you might like to keep those parts out of the sale. Like if you're a restaurant and you had dine-in services versus takeout next door. Or if you were a gym and you had boot camps, in-person personal training, and online instruction. The list goes on and on. So long as the slice of the business makes up at least 10% of the whole loaf, either in money or employee time. That's the first step of the analysis. Then, was there a government order, state, federal, or local, that closed or restricted that part? So I'm going to end this video here to allow you a minute to think about those different parts of your business that made up at least a 10% slice of the whole loaf there. I can't emphasize enough how important it is to find that 10% slice of the business. Now, take about 5 minutes to write those down and then join me on the next module.